Hello everybody, so welcome back to my English law channel. So here I'm going to talk about inchoate offences. This is part of the criminal section. So many people won't know what the word inchoate means. It means like underdeveloped. So it's a crime or a plot which is not yet matured. So there are three different kinds of inchoate offence. One of them is encouraging or abetting a crime, which can mean incitement. There's also conspiracy to commit a crime. You don't actually go and carry out the crime, but you're planning to do so. Or there's an attempt to commit a crime which doesn't actually succeed. So we always have to say which particular offence that the person is conspiring to do or attempting to do. We just can't say conspiracy. Conspiracy to what? A conspiracy to rob, attempt to what? Attempted murder or attempted rape or something like that. So there's coming back to conspiracy. There's a Criminal Law Act 1977, Section 1.1. It talks about the actus reus there. So if you agree to a course of conduct that will certainly lead to a crime, then that's a crime in itself, even if you don't actually then carry out the conduct. But this has not simply just talking about it. R against Walker prove that. If you're fantasizing about a bank robbery but don't intend to do it, if you're thinking aloud about a crime but you don't actually plan to do it, intend to do it, then that's no crime. So you don't need to agree all the particulars of the crime. It can still be a conspiracy even if you haven't filled in all the gaps. This is the exact bank we're going to rob. This is who's this person going to drive the getaway vehicle? This will be the getaway vehicle. This is the time we'll do it. If some of those are still gaps, you haven't perfected your plan yet, nonetheless you could be convicted of conspiracy. And that was it, as in R against knock. You don't need to take steps in order to fulfill this agreement. That was as in DPP against Doot. There was no Doot in that one, D-O-O-T. I'd never heard that surname before. Likewise, Nock, N-O-C-K. I'd never heard of that surname before I started studying inchoate offences. So there's certain people who cannot conspire as per this Criminal Law Act, Section 2.2. Spouses, that would include your civil partner, now that we have them. Children below the age of 10, they're below the age of reason, they can't be charged with any crime. The victim of a crime, likewise. There's a fascinating case about this, C against Krasny. I hope I pronounced it correct, Krasny, C-H-R-A-S-T-N-E-Y. So looking at conspiracy, what's the mens rea here? Is your intention to agree. So so you need to intend to carry out the crime, as in R against Anderson. There's also R against McPhillips, R against Edwards, R against Ashton, or Yip Chi Yong against R. So clause 48 of the draft criminal code is crucial here. Anyway, so you need to intend to take part in a course of action, as per R against Anderson. There's also R against Siracusa, as in, and that's an Italian chap, that city on the Sicilian east coast, Syracuse, it's known to students of classics, which had a different outcome to R against Anderson. There can be conditional agreement. Yes, I'll take part in this crime if you pay me a certain sum of money, for instance. There's R against Jackson, which is a situation a bit like that. So anyway, there are various tricky questions here. Lord Bridge sat on R against Anderson, and he said you don't need to have an intention that the crime will be committed. The mens rea requirement is that there's an intention that the crime will be committed. That's how the Court of Appeal found in R against Edwards. So these two authorities clash. We haven't quite sorted that one out. So R against Ashton and R against McPhillips are more cases about that. The Privy Council sat in Yip Chi Chung against R. That was a Hong Kong case. Because before 1997, the Judicial Committee of the Privy Council was effectively the Supreme Court for Hong Kong when it was still a British colony. Clause 48 of the Draft Criminal Code, there's another problem. The Lord Bridge in R against Anderson said the defendant must participate in the crime to some level, even if a small one. And the Court of Appeal heard a similar case. Lord Justice O'Connor sat on R against Siracusa, and he said this is not needed. So the defendant does not need to participate in the crime whatsoever. It's sufficient that he intended to. So again, these two law lords disagree. Who's correct? So there's a clash of authority. Well, let's look at attempts. There's the Criminal Attempts Act 1981, Section 1.1. It sets out the actus reus. It says that the defendant must do something more than merely preparatory to the commission of the offence. So he can't simply prepare, has to do more than preparation. Okay, so you, for your armed robbery, you get your gun, you have your getaway vehicle, and maybe you drive to the bank, and then you try and get some money, and you fail to get your money. I suppose that would be an attempt. Because you haven't simply prepared, you haven't simply got your gun and decided to do it, you haven't simply got your getaway vehicle, you've actually tried to do it, even if you had to abort halfway through, even if you failed. So the actus reus here, R against Gulliver, was about this. It said, when the merely preparatory act comes to an end and the defendant embarks on the crime proper, close quotation. That's a definition of an attempt. R against Tosti, in this case, we had to tell apart what a preparatory act was under section 1.1 and an act which is merely preparatory but it's not actually an attempt. So there was R against Jones in 1990 about that, R against Campbell in 1991, and R against Geddes in 1996. So there must be an intention to act as per section 1.1 of the Act, and you must try to bring about this action, commit this crime, right, the actus reus. So this is a resultant offence. The intention must be to achieve a certain result. Even if you fail to achieve that result, then we still have an attempt. So the mens rea for attempted murder is trying to kill, because that was the result you're trying to achieve, the death of that other person. That was found in R against Wybrow. The mens rea for attempted basic criminal damage intention is to damage property, as in R against Toole. Now, there are other aspects of the mens rea which are the same as the mens rea for the successfully completed crime. That was as per Attorney General's reference number 3 of 1992. There are a number of Attorney General's references. Each year the Attorney General puts it to the Supreme Court, well, please define this. And then they're numbered, number 1, number 2, number 3, number 4, for all the references he seeks each year. So Attorney General's reference number 3 of 1992. Looking at the Criminal Damage Act, section 1.2, it says a person who, without lawful excuse, destroys or damages any property, whether belonging to himself or another. A, intending to destroy or damage any property, being reckless as to whether any property would be destroyed or damaged, and intending by the destruction or damage to endanger the life of another, or being reckless as to whether the life of another would thereby be in danger, shall be guilty of an offence. Close quotation. So that's, okay, so intends to destroy or damage a property of another, or even his own property, and intends by that to endanger the life of another person, okay, or being reckless about that. You try to destroy the damage of property of another, but you want to actually endanger someone else's life, or you're reckless. Even if it actually doesn't endanger somebody's life, the fact that you intended it, or the fact that you were reckless about it, that is sufficient to make you guilty of this crime. So, mens rea. There's also conditional attempts. We'll carry out this crime on the condition of whatever, or we'll attempt it if whatever condition is fulfilled. That's still a crime. That's as per Attorney General's references number 1 and 2 of 1979. So amongst inchoate offences, we have to consider impossibility. Because remember, inchoate offences are sort of incomplete ones. There are 3 types of crimes which are impossible: non-existent crime, impossibility through inadequacy, or impossibility in fact. So, for example, you plot to kill somebody not realising that she died last year. Non-existent crime, R against Taff, impossibility through inadequacy. You give someone a poison substance not realising it's not actually poisonous. Or you load your gun and you fire the gun at someone trying to kill the person, not realising actually blanks you put in the gun. There's impossibility in fact, physical impossibility. Sometimes the impossibility is legal. However, this shan't be a defence to the Criminal Law Act 1977 as per section 1.1b, and it's no defence to an attempt, the Criminal Attempts Act 1981 section 1.2 and 3. So, okay, so that's enough about some of these ones. Okay, so let's say goodbye, everyone, and please subscribe to my videos. Please donate to me on PayPal. I'm georgecallahan79@gmail.com. I urgently need donations to sustain this channel. Make sure you book online lessons with me in law, history, politics, religious studies, citizenship, geography, English as a foreign language, English literature, French, and so forth. If you're little, I can do lessons in maths and science. And I help people with essays, dissertations, interview practice, public speaking, elocution, and so forth. I'm a tour guide in Londinium whenever tourism reopens one of these millennia. Toodaloo.